Hi everybody, this is Arckady Frekhtman. I'm a New York City personal injury trial attorney, and today we are going to do a series about electrocution accidents. So these are cases where somebody has been electrocuted due to a faulty circuit breaker, faulty electricity of any type, and has suffered a serious injury, and then has filed and taken to trial or settlement a case, a personal injury case, and we're going to look at the verdict searches for these cases. I'm going to start in New York because that's where I practice, and then we may branch out and look at a few other cases. So here's the first case. This is a laborer that was electrocuted when a crane struck a power line, and this happened in New York, and it was a court of claims case. So that means it was against the state of New York. When you sue the state, you have to do it in the court of claims. And the plaintiff actually was 29 years old and he passed away. He died in this. So this was a wrongful death case. And like I said, it was brought in the state of New York and it happened in 2006. So what essentially happened was the accident itself happened on September 9th of 1999. And so the 29-year-old laborer worked at a state-commissioned project, a work project, and it was in Hempstead in Nassau County, Long Island. And he was helping coworkers that were guiding a large metal panel into a trench that had been created to hold concrete sewer basins. And the trench's walls needed to be supported by some type of sheeting to prevent dirt from falling back into the trenches. And the sheeting size dictated that it had to be lifted and guided into the hole by a crane. And so this individual was holding and guiding a panel that was being lifted by a crane. The crane touched an overhead high voltage electrical line and the client was electrocuted. And so he passed away, and his widow, his wife, acting as administratrix of her husband's estate, sued the state of New York and argued that the state violated the New York labor law. And so the lawyers for the plaintiff argued that the project's manager should not have allowed work to be performed beneath high voltage power lines. And they also claimed that the crane's operator and its spotter, who was signaling the operator, were negligent in their failure to avoid the power line. And the lawyer also argued that the worksite was not properly safeguarded and that as such it violated labor law section 241(6), and he also contended that the site violated the general safety standards under the general negligence provisions of the labor law, which is section 200. And the defendant's lawyer argued that the crane's operator, who was employed by the same subcontractor that employed the plaintiff, the person who died, they were responsible for the incident, that it was the plaintiff's employer who employed the crane operator, and it was really the crane operator's fault. And so the injury was the electrocution, and there was about 20 seconds before he was knocked off of the sheet metal onto the ground. Another coworker contended that the client yelled for about another minute before eventually dying, and the person died the same day, September 9th, 1999, at age 29, and he was survived by his wife and a son who was born in early 2000. And so his widow, the plaintiff's widow, testified that the plaintiff used to perform extensive repair work around the home and that he landscaped the property's grounds. And the estate sought recovery of wrongful death damages that included the plaintiff's past and future lost earnings, benefits, and retirement income. His son, past and future loss of parental guidance. His son had a claim for that. The estate's loss of household services, and the damages for about 90 seconds of conscious pain and suffering suffered by the plaintiff before he died. So you see, they can't sue for grief because there's no Grieving Families Act, but there's a bill right now. If the governor signs it, we would have the Grieving Families Act, then you could have more. But right now, a lot of the losses, as you can see, are pecuniary losses. So it's a very antiquated statute from the 1800s. And the defense counsel disputed the amount that the estate sought for lost wages and loss of household services The defense's medical expert also gave the opinion that the likelihood of a patient similar to this plaintiff's son reaching the age of 20 is less than 10%. So I guess what the reason they're saying that is because when his son was born, he was born with an immune deficiency disease, but the child's pediatrician testified that there's newly available treatment that could extend his life to even age 40 or beyond, and because that would give him more time to have this loss of parental guidance. But the defendants are saying that because he has this disease, it's called Wiskott-Aldrich disease, that there's a likelihood that he would only live to age 20, and therefore the loss of parental guidance damages and all the damages that would go to the son should be limited. So it's kind of like a little bit of a twisted, evil thing to argue, but see, they're arguing that he wouldn't live, and because he's not going to live, he should be entitled to less damages. And defense counsel claimed that based on the child's limited mental and physical abilities, he's not entitled to any damages for loss of parental guidance. And so the court of claims cases are decided by a judge, not by a jury. So the judge here found that the state had final supervision and control of the job site and the work performed, and he determined the estate's damages totaled $6,468,507. And it was broken down as $210,000 for past lost of earnings capability, $1.5 million for future lost earnings capability, $100,000 for past pain and suffering, $2,076,000 for personal injury retirement benefits, $497,539 for wrongful death, future loss of household services, $350,000 for wrongful death, past loss of parental guidance, and $1,650,000 wrongful death, future loss of parental guidance. So the demand in this case was $5 million, and there was no offer, and the trial took 4 weeks. And so that's basically the first case. That was the result. So it was a total of $6.468. $6,468,507. So that's the first case. Let's see what other cases. Here's the second case. This is a case where a pedestrian was propelled into electrical wires at a Con Edison excavation site. And this was in Brooklyn. And it happened in 2000, December 15th of 2000. And let me see here. The accident actually happened on August 17th. The trial happened in 2000, but the accident happened on August 17th of 1994 during a heavy rain at the intersection of Christie and Stanton in Lower Manhattan in the Bowery. Plaintiff's decedent, a 59-year-old home attendant, was struck by a vehicle driven by a defendant as she crossed the street and was propelled into defendant Con Edison's excavation site. So the jury gave the car 48% of fault and the excavation site 52%. Because what happened was that the driver of the defendant's car had difficulty seeing while he was driving, but knew that he struck something. And when he got out of the car to see what it was, he saw the decedent lying in an excavation site tangled in wires. He noted that there was a sign at the site that said "Danger Live," and he called 911 to report the accident. He testified that he saw the decedent moving for 15 to 20 minutes after the accident. And plaintiff claimed that no one came to decedent's aid for fear of electrocution, and that the electricity was not turned off by Con Ed until 4 hours post-accident. The EMS personnel testified that they believed that the decedent was dead when they arrived. Plaintiff argued, however, that there was no evidence that EMS personnel checked decedent's vital signs, but merely performed a visual review before declaring her dead. And Con Ed claimed that it believed that the area was being treated as a crime scene and did not want to interfere, and argued that the wires were actually safe because they were insulated. So the injuries were brain contusion, subarachnoid hemorrhage, bilateral arm and leg fractures, 6 fractured ribs, and the decedent's cause of death was listed as the head injury. and there was no evidence of electrical burns on the body, but the plaintiff claimed that the decedent's injuries were not serious enough in and of themselves to have caused her death, and that defendants were negligent for failing to come to her aid. And the plaintiff's expert testified to the severity of decedent's injuries, but believed that they were all treatable. And defendant's expert testified that the decedent died instantly or shortly thereafter, and that any movements noted by defendant were death spasms. He conceded, however, that plaintiff's injuries were such that none of them in and of themselves were necessarily fatal. And so the result was that the decedent, who was a 59-year-old home attendant at the time of her death, was earning approximately $30,000 per year, and she was survived by 5 grown children. The offer was $50,000 from the driver of the car that hit her, and there was no offer from Con Ed, and the demand was $100,000. The verdict was $3,220,000 and $220,500, so $3.220500, and it was a 5-to-1 verdict, meaning one juror was against it, 5 were in support. The breakdown was $3,170,000 for pain and suffering, 15 to 20 minutes, $38,000 for economic loss, 10 years, and $12,500 for funeral expenses. The liability was Con Ed was 52% at fault, and the driver of the car was 48% at fault. And the trial lasted 3 days, and the jury deliberated for 2 hours. Here's another case. Let me see, is this the same case? Oh, yeah, sorry, this is the same case. I guess they have the same case twice for some reason. Here's the next case. This case, a worker was shocked when a shovel struck a live wire. So this case was a verdict for the plaintiff. It happened in New York County, which is Manhattan. And this one happened in July 7th of 2011. And the incident, though, happened in 2003. And what happened was on June 26th, 2003, the plaintiff, a 35-year-old laborer, worked at an excavation site located on West 37th Street between the intersection of 10th and 11th Avenues in Manhattan. And he was shoveling in an area alongside a roadbed, and during the course of his work, his shovel struck a live electrical wire. He sustained injuries of his head and his neurological system. He sued the electrical wires installer, Consolidated Edison Company of New York, the premises owner, the City of New York, several entities that were believed to be operators of the premises, such as the Metropolitan Transportation Authority, the MTA, the National Railroad Passenger Corporation, and the New York City Transit Authority. And the plaintiff, his name was Manuel, he also alleged that the defendants violated the New York State labor law. The evidence revealed that the MTA, the National Railroad Passenger, and the New York City Transit Authority did not operate the subject premises. Thus, the parties were dismissed, and the matter proceeded against the city and Con Ed. And Manuel's lawyer, the plaintiff's lawyer, noted that an investigation revealed that the electrical wire had been severed by an excavating machine. And so Manuel claimed that he had not been warned that live electrical wires may have been present in the area in which he was working. And he also claimed that he had not been provided insulating equipment or protective gear. And Manuel's expert engineer gave the opinion that the defendant did not fully fulfill their duty to provide protection against electrical shocks. And so Manuel's counsel argued that the incident stemmed from an elevation-related hazard as defined by Labor Law 240, and that Manuel was not provided the proper safe equipment that is requirement of the statute. And he also argued that the site was not properly safeguarded as per 241.6, and that the defendants violated the general safety provisions of Labor Law 200. But the judge dismissed the claims that were based on violations of Labor Law 240, arguing that it wasn't gravity or elevation related, he's rather just digging and hits a live wire. And so Con Ed's lawyers argued that the wire was damaged by one of Manuel's co-workers and argued that his client could not be held liable for injuries that were caused by electrical wires that another contractor damaged. And he also contended that Manuel's employer was responsible for basically Manuel's employer buried the subject wire. that way marking the wire's location and ensuring that excavating machinery was not used near the wire. That was all the duty of the employer, right, his coworker. And so Manuel's lawyer moved for summary judgment on liability, and the judge found that Con Ed could not be held liable via application of Labor Law 240 and dismissed all of the claims against the city. However, the judge subsequently reinstated the claim that alleged that the city had violated Labor Law 241-6. So the injuries here were an electrical shock, a concussion and damage to the brain. There was post-concussion syndrome, post-electrocution syndrome, radiculitis, radiculopathy, spasms, neuritis of the brachial plexus, which comprises the nerves that service the arms and shoulders, diminishment of cognitive functions, ataxia, which is a gross diminishment of muscular coordination, and depression. And he underwent psychiatric counseling and physical therapy. He contended that his injuries prevented his performance of about 18 months of work. And Manuel claimed that his depression persists and that it greatly affects his personal and private life. And he also claimed that he suffers residual pain. His treating physiatrist and treating psychiatrist gave the opinion that he suffers permanent physical and mental injuries. So Manuel sought recovery of a total of $1 million for his past medical expenses, his past lost earnings, and his past and future pain and suffering. And the defense's expert neurologist and expert orthopedist gave the opinion that Manuel exaggerated the extent of his physical injuries. They also gave the opinion that the accident was not the cause of his depression or any diminishment of his cognitive functions. Now, the result, the jury found that the city and Con Ed were equally liable for the accident and determined that Manuel's damages totaled $525,164. And it was broken down as $20,164 for past medical costs, $180,000 for past lost earnings capability, $200,000 for past pain and suffering, and $125,000 for future pain and suffering for 40 future years. And so the demand was $1 million, there was no offer, and the trial took 9 days. The jury deliberated for 1.5 hours. It was a jury of 1 man and 5 women. And post-trial, the judge awarded interest in the amount of $5,309, and the total recovery was therefore increased to $530,473. So those are basically some of the cases in New York. And maybe we can do a video later and do some cases in other states that involve electrocution. I see there's one other case here for $500,000. There's a case here for $250,000. I think after the cases I've done, this is just searching the word electrocution. And the final case I see here is actually a defense verdict where the offer was 0. So I'm not going to have time to go through all these cases, but next time I can maybe look at some of these cases as well as cases nationally for electrocutions. Because we have handled a few electrocution cases as well as some fire and burn injury cases. So I thought it was interesting to look at the verdicts and the results all over the USA. Okay, everyone, please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. If you have a question, just text me, 347-566-9595. I'm happy to get on the phone and do a free confidential consult call. Just text me your name, brief facts of what happened, and your injury information and your city, so I know who you are, what happened to you, so I could see it, and a little bit about your injury or your medical diagnosis if you have one already, and what city you're in. And we've been working with people all over the United States and finding some of the best trial lawyers, and it's led to some amazing results. I'm happy to report that one of the cases down south in the state of Georgia settled for more than $2 million, with the client being very, very happy. And that was because of a trial attorney that we personally worked with and partnered with down there that was able to effectuate that result. And we have cases now in Florida, in California, in Idaho, Wyoming, Oklahoma, Texas, all over. So we look forward to helping people. Okay, thank you so much. Have a great day.